All right, this is case number 21-170377. This is Luther Appliance and Furniture Sales versus Candace Allen. The matter is before the court on an application for show cause. Your appearance for Luther Appliance, please.
Michelle Bourne-Fisher on behalf of Luther Appliance and Furniture Sales.
Your P number for the record, Madam Counsel.
P67527.
All right, thank you and good morning to you. Do I have Candace Allen on this Zoom? If you're here, please say something at this time. Or Candace Allen. This is a person reportedly living at an address on Ingleside in the city of Detroit. If you on this Zoom, please say something at this time. It appears this matter is set on for 9:30 a.m. It does appear that the respondent has not appeared for this hearing. Madam Counsel, your pleasure at this time.
Your Honor, I show that she has been served with the show cause hearing. She was personally served originally with the debtor exam, so I would ask for a bench warrant.
All right, very well. Given that the defendant has been served as not, the respondent has been served and not appear, the court will issue a bench warrant in this matter. And how much was the judgment in this matter, Madam Counsel?
The judgment was for $1,404.15, and there's just a little over that owed now.
All right. So I'll set bond on the warrant at $1,600, and you can send that to the court, and I'll sign the bench warrant upon its presentment. Now you can send that by email if you wish to do so. And do you have the email address here?
I don't.
Okay, so let me go ahead and give you that. That's Latifah, LATIFAH.Hunter at 3636th 36districtcourt.org.
Great.
All right, thank you, Counsel. Good day.
Thank you so much. Have a good day.
All right, the court calls case number 22-182-312. This is ZMC Pharmacy LLC versus Suburban Mobility Authority for Regional Transportation, SMART. The matter is before the court, set on for a pretrial conference hearing. Your appearance at this time for the plaintiff, please.
Good morning, James Tantalo on behalf of ZMC Pharmacy.
And your P number, Counsel, please.
85401.
Thank you, Counsel. Good morning to you. For defendant SMART, please, your appearance at this time.
Morning, Your Honor. Joseph Giacalone, P85482, appearing on behalf of defendant.
All right, thank you. That's Mr. Giacalone. All right, and good morning to you. I do see where the court issued a scheduling order that allowed for discovery in this matter and set the matter over with opportunity for motions if parties wish to present the same. So somebody update me on where you are with this matter. I know you've had some that allow for discovery. Go ahead.
Well, we have exchanged some discovery and interrogatory. Looking at my case notes here, it looks like we issued answers to defendants' first interrogatories just a couple of days ago. And I believe that all of the responsive or discoverable documents have been turned over to defendants. And so at this point, I believe that plaintiff side has submitted everything that can be done. However, if defendant SMART has any interest in extending discovery, I would be amenable to that.
Yes, Your Honor. As Mr. Tantolo said, we got the discovery answers on Monday from plaintiff. At this time, we believe additional time is necessary in order to come to a resolution in this case. Since plaintiff's counsel is amenable to extending discovery, we would like to extend discovery as well.
All right. So what other items are needed? What do you yet anticipate by way of discovery? Because I can give you some time to kind of go forward with engaging in practical negotiations in terms of trying to resolve it. But if you actually need this stuff, the extended thing, there are some other things out there. I guess I kind of want to know what you're expecting or what you're anticipating in terms of.
At this time, Your Honor, we're also defending the claimant's main suit against Smart. That case, the plaintiff is also plaintiff is an intervening plaintiff. Mr. Tantolo's firm has an intervening plaintiff in that case as well. That case is set to go to a trial in January of 23. There may be a chance to go to facilitation to resolve all the claims that involve the underlying claimant, Mr. Murdaugh. At this time, having the flexibility in order to potentially raise that as an option or to have other, if other issues in discovery come up, we're trying to find authority with Smart as to what we would need to do to resolve this case.
So that's the other case, the principal case in certain court, is that correct?
That is correct, Your Honor.
All right, well, it makes sense to me. So I'll go ahead and allow for continuing discovery, and then I'll set the matter for view. I'm going to do that on the 1st of December. Oh, actually, that's the 7th of December, December 7th. And I'll take a review at that time. I understand the posture of the case at this point. And so I'll just set it for review on the 7th. Discovery remains open. And that's going to be at 9:45 on 12/7/2022, 9:45 a.m. And then I'll hear you on your updates at that time. And we'll see which direction this should take, right? That makes sense to you, Mr. Tannenwald, as well, sir?
Yes, Your Honor.
All right. All right, thank you, gentlemen. Matter be continued. The scheduling order is extended through the 7th of December 2022. The court will conduct a new hearing on that.
Thank you, Your Honor.
Thank you, Your Honor.
Oh, wow. There we go. Thank you.
Right, the court calls case number 21-144120. This is Anderson Medical Supplies Incorporated versus City of Detroit. The matter is before the court set for a pretrial conference. Your appearance for Anderson Medical Supplies, please. For Anderson Medical Supplies. For the
Your
City of
Honor,
Detroit.
sorry.
Sorry, Madam Counsel.
I was just about to say, I don't think plaintiff's counsel is on the call.
All right, thank you. For City of Detroit.
Charlotte Bennett, P number 85699 on behalf of the city of Detroit.
All right, thank you. Thank you, Ms. Bennett, and good morning to you. So sounds like you've got some insider information. Tell me what's going on.
I don't have too much insider information for you, Your Honor. We were talking settlement a few weeks ago. Admittedly, I haven't heard from plaintiff's counsel in a bit, but I did just realize that I believe when we substituted in as counsel for defendant in this matter, that we were accidentally put as counsel for plaintiff. So as of this morning, I don't know if plaintiff's counsel got notice of this pretrial conference. So at this point, I would just request that we adjourn this even just 30 days just to resolve that issue and give plaintiff's counsel a chance to be here. Because I certainly don't want to do anything without them if there's been a mistake like that.
Gotcha. All right, so I will look to see that that is not occurred. Now, who is plaintiff's counsel in this? Let's just check our.
Yes, Your Honor, plaintiff is represented by Kusan Hamoud, by Ali Kusan. Or Ali.
All right, very well. And Ms. Bennett, we will renotice this. And
Okay.
at your request, under these circumstances, I will set it over for some 30 days. That's going to put us at. All right, that's going to put us in November the 2nd, actually. So 11/2, and that's going to be 9/30. 11/2 at 9:30 a.m.
At 9:30 a.m. Okay, Your Honor, that works for me. Do you need anything from me regarding the substitution issue?
It would be good. I did not see an order of substitution. If you would present something along those lines, I'll get it all signed up and that will make sure.
Absolutely, Your Honor. I do believe you signed our order of substitution, but I can email back to the clerk the true copy that we got.
I'm taking a little bit of a look. And it's not jumping right out at me, so if you could, hold on 1 second. Let me look at one other.
Yeah, it was a while back, Your Honor. It looks like the one we have was signed by you on January 26, 2022. I don't know when the confusion happened with plaintiff's counsel, because he's definitely been here since that substitution order was entered, but that's the true copy that we have is dated for that date.
All right, very well. So yeah, get that over to me and let me make sure I've got everything aligned here. So
Absolutely, Your Honor. I'll send it over.
got it. I found it. Okay. So
Okay.
I'm going to put that in my clerk. So you don't need to send another one.
Okay.
I'll put that in front of my clerk and make sure that we got that. And you're with the Bass office, is that correct?
That's right, Your Honor. I'm here for Mr. Voss this morning.
All right, thank you. Well, we got it all set, and I'll make sure that the notices go out in the manner that they should. Thank you, Counsel.
Okay, thank you, Your Honor. Have a nice day.
This is case number 21-160-918. This is William Buford versus Progressive Marathon Insurance Company. The matter is before the court set on for a pretrial conference on today's date. Your appearance at this time for the plaintiff.
Good morning, Your Honor. Doug Harris-Gavich on behalf of the plaintiff, William Buford, P81458.
Right, thank you. Good morning to you, sir. For Progressive at this time. Look at our Allstate Insurance.
Good morning, Your Honor. James Flynn, P84708 for defendant Allstate.
All right, thank you, counsel. Let me ask you for the plaintiff. I see that you entered your appearance for Buford. Is anyone appearing for Alice Tillman?
I don't believe so, Your Honor.
All right, very well.
Your Honor, I believe Progressive and Tillman were dismissed from this. Brother counsel may be able to, I believe I saw that in there, a dismissal for them.
I think you are correct.
I'm sorry, say that again, sir.
I think he is correct. I'm checking right now.
Yeah, Progressive is no longer in. I'm pretty sure. And I was wondering about the other plaintiff that I had, which is Alice Tillman. All right, so I know that there was an order. I issued an order for competency regarding Mr. Buford. So somebody updates me. Go ahead and tell me where we are.
Yes, Your Honor. So last time we were here, we agreed to amend the complaint to reflect the new guardian for Mr. Buford. We've agreed on a stipulated order that has not yet been filed because I've been attempting to get in touch with the new guardian, Destiny Tompkins. I have been unsuccessful. It goes to voicemail. So we are looking into sending someone out to her last known address, trying to get some kind of correspondence because we can't really move forward without her permission.
And she's newly appointed, I suppose.
Yes.
All right. All right, Mr. Flynn.
Your Honor, we just need that updated or amended complaint, and then we'll seek the deposition of the guardian. So that's helpful information. to know what's going on there, but we just need that deposition before we can move forward in a meaningful way. So whenever that you're able to make contact or whatever ends up happening, we're ready to notice that deposition when appropriate.
Sounds good. Sounds good. All right, so so I give you some time to go ahead and try and get that person actually on the file so that you can get the complaint amended accordingly. As a matter of course, I would be inclined to grant such an amended complaint, of course, under these circumstances. So you kind of updated it. How much time do you think we need on this, council?
Can we get 60 days?
That's a lot. All right.
I mean, within that time, we would also attempt to complete the deposition as well.
All right, that makes sense. So let's bring it back. Let's bring it back in December. December the 7th is the date that I'm working with. And actually, I need to move it over to the date. So December 8th, 2022. That's going to be 9:30 a.m.
That works, Your Honor.
That works for defense, Your Honor.
Thank you.
All right, we'll see you on that date.
Have a good one,
Thank you, Your Honor.
Moment, everyone. All right, the court now calls 22-178-778. This is Citibank versus Alex Knox, also known as Alex Mabry. Matter is before the court, set on for a pretrial conference on today's date. Looks like I received a response of pleading in this matter. It appears, actually, this is not the first hearing. I've set forth a scheduling order. Your appearance for Citibank, please.
Preston Nate, P77884, appearing for Citibank.
Thank you,
Good morning, Your Honor. Brian Parker here for the
for
defendant.
the,
Thank you.
for the defendant. Excuse me.
Brian Parker for the defendant. Hello.
All right, your appearance, counsel, again, let me get that because we're talking over each other. Your appearance and P number, please.
My fault, Your Honor. Sorry. Brian Parker, P48617 for the defendant. Thank you, Your Honor.
All right, thank you, Mr. Parker. Good morning to you as well, sir. All right, somebody update me. I know that you've had this period of discovery. Let's see how far along you got. Go ahead and talk.
I'll give a little update, and Brian, if there's anything extra, just let me know. But the parties have been in contact with each other. We thought we might have had something worked out earlier, but that might not seem like the case at the present time. I guess we would ask the court if we can adjourn this pretrial 60 days to maybe try to work out the differences that we have. And then leave, if we're able to also file motions within that time period, if needed, that would be probably acceptable at this time.
You think you need 60 days for that, Mr. Parker?
Yes, thank you very much, Your Honor. The law firms work exceedingly professionally quite well with each other, and we settle 99% of these cases. And so we have a very, very good relationship. The only thing I would ask, I agree to everything that was said. This may seem adversarial, but I would like the right to, in 30 days, file a third-party action against Stenger and Stenger. And I've explained this to brother counsel, and the executives above that, and we're all good. I don't want to destroy any relationship, but I gotta protect my client too.
All right. Well, I know it's gonna be difficult for Mr. Nate to say that he concedes to a third-party action. But in any event, I will grant you that 30-day window within the period that the court is going to grant that you wish to proceed with such an action. You can do it within the next 30 days on or about the 28th of October of 2022. The court will set the matter over for hearing on November 30th. Bring it back November 30th. We're going to set that up for 10 o'clock a.m., 11:30, 10 o'clock a.m. I'll see you at that time, gentlemen.
Thank you, Your Honor. Thanks, Brian.
Thank you for your learned instructions here, Your Honor. I hope everything goes fast today.
All right, thank you, sir. Good day.
Bye-bye.
I do have another one with Your Honor, so I will stay on the Zoom call.
All right, thank you, sir. This is case number Case number 12-109-896. This is Merchants Credit Recourse versus Antoine Holcomb. Matter is before the court on the following of objections to a writ of garnishment. For the plaintiff, your appearance at this time.
Good morning, Your Honor. Sidney Katz, P51471 on behalf of the plaintiff. Long time no see, Your Honor.
Likewise, sir, and good morning to you. Is this the, do I have Mr. Holcomb in the courtroom? Is that the gentleman that and ma'am, your name for the record, please. Yes, your name for the record, ma'am.
Judge, I'm Michelle Blanks, car provider for Mr. Holcomb.
All right, thank you. And I'll raise your right hand and be sworn at this time. You just solemnly swear or affirm that you will provide the truth as to any statements communicated to you by Mr. Holcomb to the best of your ability, so help you God.
I do, Your Honor.
Thank you very much, sir. Okay. All right, and your name for the record, sir.
Your Honor, this is Mr. Antoine Holcomb, ANTOWAN HOLCOMB.
All right, thank you. Thank you, ma'am, and good morning to you, Mr. Holcomb. This is your petition objecting to the garnishment. It says that the garnishment should not proceed because you filed bankruptcy and this matter was discharged. Is that what you wish to communicate to the court?
Right.
Mr. Katz.
Your Honor, I did receive a phone call from an attorney. I did receive a phone call from an, do you hear me, Your Honor? I did receive a phone call from an attorney. I did call him back. It seems that there was a bankruptcy. My office never received a copy of that. So if we could adjourn this, because if there in fact is a bankruptcy, then we will just submit the necessary dismissal, and any amounts that were taken in during that bankruptcy period will be refunded to the defendant.
It seems that Mr. Holcomb has a document that he would like for the court to look at. And I'm going to take a look at that document to see what that is. And then I'll tell you, Mr. Katz. what that document is. So Mr. Holcomb, you can, well, he's handing me a package of items. So I'm going to take a perusal to see what those items are. So I've received 3 documents. One is a 2-page document. The 2-page document is an order of discharge document by the Honorable Philip Sheffield, United States Bankruptcy Court. This is in relation to Mr. Antoine Holcomb. It has it is a case number of 1951567 PJS, and it is a Chapter 7 discharge, which indicates a discharge date of 11/13/19. The second document that I have is directed to Mr. Holcomb regarding notice of income tax refund used for debts. And this apparently is in regard to the notice of intercept and the intended refund amount set forth as $1,908. Then there's a handwritten note that says, "Good morning, how are you? I have proof of bankruptcy, so merchant credit reports can't garnish my income tax check. I want my $758.48 income tax back or garnishment form, please." My bankruptcy attorney said credit merchant is wrong. All right. So that's those are the items that I've received from Mr. Antoine. So, it seems that that there is an order of discharge under Chapter 7, and it is dated to 2019.
Your Honor, I'm aware that that does exist. I'm just trying to find out why my office never received a copy of it and why it slipped through. So our intention at this point is to refund Mr. Holcomb whatever we could determine has been received by our office that should not be our funds. So if we could just set this for a second hearing date, hopefully we won't have to come back. But this way, it's still on the court's docket to confirm that we have in fact made Mr. Holcomb whole.
All right. So what I'm going to do is I am going to adjourn the matter for 30 days. That is to give a control date to the respective parties. It is anticipated that given that there seems to be competent evidence that a discharge of bankruptcy, that any funds that have been garnished would be refunded and any present garnishment would be set aside. I'm leaving it to the parties to get that detail worked out over the next 30 days. If such relief is not forthcoming or turns out to be for some matter unwarranted, then the parties will have an opportunity for redress as well before 30 days hence. So I'm going to set this matter over for the 2nd of November 2nd, and I'm going to set it at 9:38, November 2nd, 9:38.
Thank you, Your Honor. Your Honor, if Mr. Holcomb could just, I think he has my email. If he could email me with his address so that we do know that if we have to send him funds, we have the correct address of where that's going to.
All right. I have the address on the notice of hearing. Did you receive the notice of hearing document, counsel?
I do, but I put it on my calendar and I might not have that notice anymore. That's my concern.
All right, very well. So what I wanted
If
to
the court can put it on the chat, then I could pull it off of there.
Yeah. You're trying to work me a little bit. But here's what I had in mind. That's one better, Mr. Katz. If you would direct your email address in the chat,
Yep.
I'll send on a copy of the order of discharge as well as the notice with Mr. Holcomb's address.
Perfect. Great.
Okay.
Thank you, Your Honor.
So just give me, send your email in the chat. I may have it here somewhere already, but if you put it in the
Okay,
chat.
I will send it.
I have to email copies of these documents over to you. So that you.
Great. Thank you, Your Honor.
All right, anything further, Mr. Holcomb, that you wanted to bring to the attention of the board? One moment.
Your Honor, I just sent that over to you.
All right, thank you, sir. I see that it's there in the chat. We'll read those items out to you.
Your Honor, he says, will I get my payment back from them?
And it is the intent to resolve this in a way that is consistent with the bankruptcy. The plaintiff is yet reviewing that. To the extent that the bankruptcy is what it appears to be, then anything that happened as far as collecting money from you would have to be refunded, and any current garnishment would have to be set aside. The next 30-day period will review that. If that's not the result that you get, then you have recourse in front of me on 11/2/22 at 9:30 a.m. All right, so the matter is set then at this time. I'll review the matter on 11/2/22 at 9:30 a.m. And the issues, it seems that this case may be worked out, but if there is a problem, I will address what the problems are on 11/2. Good day to all.
Thank you, Your Honor. Have a good day.
I'm going to return your documents, Mr. Holcomb, but I'm going to make a copy of the bankruptcy document first, so that I can send a copy of that to Mr. Kent. We'll get this right back to you. So my clerk stepped out for a moment. So as soon as she's back, I'll get a copy of this, and then I'll give them this document. Okay. Make a copy of that. All right, this is case number 21-14-5595. This is AZ Electrical Engineering versus Jenkins et al. The matter is before the court, set for a review hearing on today's date. Your appearance for plaintiff regarding this matter.
Good morning, Your Honor. Sam Jarbo, PA 4564 for the plaintiff in this matter.
Thank you, Mr. Jarbo. Good morning to you, sir. For defendants in this matter, your appearance, I see there, Mr. Patterson, your appearance, sir.
Yes, Your Honor. Andrew Patterson on behalf of the defendant.
All right, give us your feed number for the record, sir.
18690.
Thank you, sir. Good morning to you. All right, somebody update me. I know that you had a portion of this that it seemed that there was a resolution and you were working on part 2, kind of. So give me an update. Let's see where we are at this time.
Your Honor, we're actually we've come to kind of a standstill, and Well, Mr. Patterson, I think that the best course of action would be to have this case move up to a circuit court. But he doesn't want to admit that the damages amount to circuit court. So we're asking for the purposes of, transferring the case, that we be able to dismiss this case without prejudice. And then I'd refile my matter in circuit court, and then Mr. Patterson would then follow suit.
All right, if that's the way that that you best get to your result, then that's fine. I don't know by stipulation transferring it to circuit court that would be an admission of.
I think we're gonna. I think we dismiss. The best course of action would be to dismiss here without prejudice, and then allowing me to.
I heard you, Mr. Jarbo. I know that seems to be the approach that extends more time. So I was looking if there was another way of backing into that. Mr. Patterson, anything, sir?
No, Your Honor, I'm just happy to try and accommodate him on this. I've just seen nothing though that indicates to me that we're within the jurisdictional amount of the circuit. But if we are, we are. I think we'll ultimately get this resolved anyway. But
I think so too.
But I've not seen anything that substantiates his claim yet.
All right, very well. Got it. All right, so I will sign an order voluntarily by way of stipulation dismissing this matter. And that order anticipates that it would be refiled in the circuit court. So I'll sign an order consistent there with it. Somebody could send that to me by email. I'll get it signed off right away. That email address is Latifa, L-A-T-I-F-A-H. Hunter is the last name.
I'm sorry, Your Honor. Can you restart with that email?
Gotcha. That's Latifa, L-A-T-I-F-A-H .Hunter at 36360 districtcourt.org.
Thank you.
Thank you. Good day to you, sir. Good day, Mr.
Thank you, Your Honor. Good day to you.
Thanks, Drew.
This is case number 21-171-367. This is Credit Acceptance Corporation versus Robert Lee Davis Jr. and Tiffany LaShawn Davis. All right. Let me have your appearance. I don't have a complete file on this matter. So let's have your appearance for the plaintiff.
Judge, may I please call Attorney Richard Bruson? My bar number is 35222. I'm the attorney for the plaintiff. I'm also the respondent to defendant's objection to a wage guard and income tax guard. And I believe there's also a motion for installment payment scheduled today.
All right, and I do now have the file on this. There was a jacket that separated the two, and I do see the objections to the writ of garnishment. I also see the petition for installment payments regarding this matter. It looks like there are two objections to garn. One that relates to Michigan Department of Treasury. The other relates to the Barbara Ann Carmel's Cancer Institute. On the objection to garn regarding the Carmel Institute, it provides I never received any documents to make arrangements with the plaintiff before now per my employer. On the objections to the garn with respect to Michigan Department of Treasury, it says I never received documents with regard to this issue since 2009 when the car was recalled by the plaintiff. And then I see the petition for installment payments that are petitioning, asking for payments of $50 every 2 weeks. All right, do I have Mr. or Ms. Davis on the Zoom at this time?
Yes, you have Tiffany LaShawn Davis.
Thank you, Ms. Davis, and good morning. Good morning.
Good
to you,
morning.
ma'am. All right, these are your petitions, of course, and Mr. Rusin has responded to these items. And it looks like in each of these items, you're basically saying that you wanted an opportunity, some type of way to have a payment arrangement. Is that correct?
That is correct, because basically I didn't receive anything prior to this garnishment being put into place. When I reached out to them once my job notified me of the garnishment, I never got anything in the mail. They were sending everything to an old address, but they did have my new one. So, that was like, a little upsetting that no one tried to reach out to me about this, because the last I heard that I could get the vehicle back in 2019, but then they sold it. And then when they sold it, that was the last I heard.
So yeah, I am seeing I'm seeing an address on Hall Street and Kelly Road in the file, and I'm seeing where there was a petition for alternate service, and that petition was granted, and alternately service was made by substitute means, and that's how this case got in front of the court for purposes of judgment. All right, Mr. Wilson.
Judge, I noticed that defendant contacted my office on or about September 19th to indicate that she's willing to settle the entire matter in whole with a settlement payment to me that I'm supposed to be receiving in hand by December 12th, 2022. I would query defendant if that still is in place, if that's going forward, or where we stand at this time.
Ms. Davis, you made you don't have to tell me what it was, but you made an offer of settlement to resolve this by December. Is that what it was?
They explained to me that there was a settlement amount of $3,800 and something, but they were still going to garnish me to get those payments, and I had up until December the 12th, I think it was, to pay that off in full, which with them garnishing 25%, that wouldn't have paid that off.
So go ahead, Mr. Bruce. Well, so it looks like, again, let me say this. It looks like if there's a settlement, maybe you need to talk in the breakout room to see if we can bring this world together. And what seems, and I'll just throw it out there, what seems reasonable to me is maybe the partial payment is set up towards that end, and then you lump sum it some kind of way in December. Is that? Well, why don't the two of you talk in the breakout room and see if you can and see what you're really trying to do here, and then I'll come right back to you. Mr. Rosen, that makes sense to you, sir?
That makes sense to me, Judge. Thank you.
All right, ma'am, that makes sense to you as well?
Yes, that makes sense. Thank you.
All right, so there's your notification, and then I'll come right back to your case, yeah?
Your Honor. Your Honor.
Mr. Nate, yeah. You're calling for me, Mr. Nate. Hold on. I thought it was you.
I'm sorry.
Hold on a second. Who's talking to me?
Yes, Your Honor, Mr. Holcomb has a question. He
Yeah.
wants to know that if the, if merchants, credit recourse sends the money before the November 2nd date, does he still need to appear?
No, if you get it all worked out, it doesn't have to appear. Okay? We're not on the record with that. That's off the record. but-
No, I have to.
Yeah, I know what you're doing. You're communicating to him. But yeah, he does not have to appear on that date as the case will be resolved. And that's what we anticipate. We anticipate that the case will be resolved before that date. That date is to give him a recourse, that if it doesn't get worked out, you come back and see the judge on that.
Thank you, Your Honor.
All right, thank you. All right, good day to you. All right, this is This is case number 21-156814. This is LVNB Funding LLC versus, looks like Sankia Powell. The matter is before the court on the filing of objections to a writ of garnishment. The record should reflect that a judgment was entered in this matter by default for the total sum of $1,042.46. That judgment was entered on the 22nd of February, 2022. The objections to the writ of garnishment does not set forth any basis on the form for the objection. Your appearance for LVNB funding, please.
Preston Nate, P77884, appearing for LVNB funding.
All right, thank you, counsel, and good morning again. I'm looking now for Sankia Powell. If you're on the Zoom, say something at this time.
Yes, Your Honor.
All right, what is your name?
Sankia Powell.
All right, I got it right. Okay, thank you. Good morning.
Yes.
To you, Ms. Powell. All right,
Good morning.
I have received your objections regarding, look like Meadow Lodge of Southfield.
Yes.
So this is a wage garnishment, is that correct, ma'am?
Yes.
All right. So you didn't put any reason as to why you're objecting. So tell me what you're asking the court to do here, ma'am.
Well, I need maybe a more affordable amount to pay.
All right, that's what I kind of figured that you were aiming at. So has any money been garnished from your paycheck yet?
Yes.
So-
Payment of, yes, one payment so far.
One payment. How much was that payment, ma'am?
It was $358 and some change.
Wow, that's big. Was that so? You get paid every 2 weeks?
Yes.
Okay. So it looks like you would be the garnishment would hit you at about over $700 a month, correct?
You say how much now?
I said, it looks
Oh,
like the
yes, it
garnishment-
would. Yes,
Yeah,
it would.
$700 a month.
Actually, that was just probably not, because I don't really get those hours. It just happened that it was like a holiday and extra hours on my paycheck.
Hold on 1 second, ma'am. Hold on 1 second.
The email address that you for the chat, for the chat.
Yeah, I'm sending, yeah, I got, let's send the documents to that.
He wants his email. So he can.
This is what you want.
Okay, email that.
This document. And this document.
Okay, so that document has what? Email that to Kat.
And this.
Okay,
This is just so.
okay. I'm gonna give this address. Okay, and with these documents, you want me to do it?
This is just the file. This
Oh,
is
just a file, okay.
It's old.
As he's all saying, he doesn't have to return unless they don't work it out.
No, this is the return.
Okay.
Then
Then he does not have to return.
Right,
Okay, all
that's
right.
that's a return.
Okay.
Okay, sorry for the interruption, Ms. Powell, and thank you for your patience, Mr. Nate. Go ahead, Ms. Powell. Well, how much did you want to pay on this a month? it was $1,000 judgment. It looked like you paid 300 and something already now that they took that garnishment. We could stop the garnishment. Tell me what do you want to set up as a monthly payment to try to resolve this?
I could maybe afford like maybe $50 a paycheck.
That's like 300 a month. You want to pay 300 a month?
No. I get paid bi-weekly.
Yeah, but if you pay 150 bi-weekly, that's 300 a month, right? How much are you
I'm
saying?
gonna pay 50.
How much?
I'll say $50.
Oh, $50 a month.
Yeah, $50 a paycheck. Maybe like
Paycheck.
$100.
And $100 a month. Okay, that's so that
Yeah.
would be 100, correct?
Yes.
Okay, we're on the same page.
Mhm.
All right, Mr. Nate, what do you think about that, sir?
Yeah, I haven't received the garnishment payment of the 358 that you'd indicated, but assuming that gets to our office, that leaves, like you said, about 700 and something left. That means that would be paid off roughly 7 months. I don't have any problems with that. If she feels comfortable doing 50 bi-weekly, I think we can make that work.
All right, very well. So what I'm going to do, ma'am, is just as I go through the form, the objections are not really valid because you didn't really give any reason for objections. So
I'm sorry. I can't.
That's okay. That's okay. We'll walk through the process. I'll release whatever funds have been withheld to the plaintiff, but then I'm going to suspend I'm going to suspend the garnishment, and I'm going to allow you to pay it voluntarily at $100 per month. So your first payment.
Will he? I'm sorry.
You just ain't gonna listen, are you?
I'm listening. I'm listening.
I'll let you say something on the other side. But here's what's gonna happen. The order that I'm gonna sign is gonna stop the garnishment as long as you're making the partial payments. Your first partial payment in this matter is gonna be due on the 21st of October. 10/21 will be your first partial payment. And I'm going to give you an order that's going to stop the garnishment. Is really a suspension of the garnishment. So they stop taking money out of your check, and you'll be able to pay it voluntarily. The money that they already took, that money is going to be released to the plaintiff to go towards paying this down. So you'd have a balance of about 700 starting in October. You pay 100 a month, and in roughly 7 months you'll be all done. That makes sense to you, ma'am?
Yes.
Anything you want to say? Anything you want to ask?
Well, I know I wanted the money to stop coming directly out of my check, but I really still needed to just come directly out of my check. So how do I set that up for the $50 to still come out?
Well,
payroll or?
You can, Ms. Powell, you can just call our office. I'll have the payment plan all set up the way the judge set it up in your file already. So if you want to just call our office whenever you have a chance, they can set up those automatic payments for you.
Okay.
Okay, so whatever you need to do there, ma'am, contact their office to let them know about the partial payment order so you get that all set up, because you got to make that $100 payment some kind of way by October the 21st so that you don't miss the payment plan. Okay.
Okay.
All right, so I wish you well. Why don't you chat me your email address, and I'll send you a copy of the order that suspends the garnishment, so they won't take out any more money prior to your next date.
Okay.
I'll send you mine as well,
the
Your Honor, if you want to include me on that same email.
All right, Mr. Nate. Yeah. Oh, you put yours in as well, correct?
Yeah.
Okay, so I'm going to send a copy of the partial payment order and the objections, the order on the objections to both parties by way of email. So make sure you put your email address in the chat, Ms. Powell.
Okay, how do I do that?
I don't know. On your device, you should have a place where you can chat. You see it? You know, or use a cell phone or what?
I know how to use a cell phone, but I don't have a chat option here.
Were you just calling in on the phone line, Ms. Powell?
Yes, I called in. Yes.
So she might not have that capability.
Yeah, I don't have that feature. I'm just on the call.
Okay, well, it should be on there somewhere, but you can't find it. Mr. Nate, will you get an email copy to her or something, once you get some information? Because I want her to get that as soon as she can, so she can get it to her employer, take it to the personnel so they can stop.
Sure. Yeah. I guess if you want to throw us into a quick breakout room, I'll get an email from her, and then when I see that, I'll forward it to her.
That's what you said. The sound is a little bit distorted, so that's what I'm doing. So, Mr. Nate, I am sending you a notification now. And ma'am, I'm gonna send you a notification as well. You'll see it come up on your phone and just go ahead and click in.
Thank you, Your Honor. I appreciate it. We'll just take off when we're done here. We won't bother you.
Sounds good. Sounds good. Got it, Ms. Powell? I think she's already there. All right. So we're back on the record in credit acceptance versus Davis et al. And the parties did go into a breakout room to speak on this a bit. Mr. Rusin, if you will, has responded. If you'll update me, sir.
Judge, may I please court Richard Grusin for the record. On the breakout room, we went over the agreed settlement that I referred to on the record before going into recess. Defendant confirmed that that settlement. She's waiting from the letter which I mailed out from my office September the 19th, but apparently and circling back to Harper Woods, it's a little slow down there. But that being said, so I'm prepared to stipulate to granting defendant for installment payments, which is filed for $50 be paid every 2 weeks, beginning October 28th, 2022. I would also ask that the court deny the objections to wage garnishment and income tax with the entry of that stipulated order.
All right. That makes sense to you, ma'am?
Yes, sir.
And Mr. Rosen, it will be understood that the garnishment would be stopped as it relates to, or suspended as it relates to the Carmanos Institute, correct, sir?
That is understood, Judge, yes.
All right, very well. So I'm going to sign the orders consistent with the same, and I will issue the partial payment order that allows for the payment of $100 a month and $50 installments per pay period. And you'll receive copies of that. I'll get that out to you right away.
All right, thank you, Judge.
Thank you, Your Honor.
Thank you. Good day to you.
All right, I'll see
Thank
your
you,
next
sir.
one.
Thank you, attorney.
Thank you. I'll see you in Judge Adams' docket, Judge, if you're going over there.
You didn't tell me about that. Who was it?
Are you still on the record?
Yeah, just one second.